All right, I call this special joint meeting, City Council, Committee of the Whole, and Planning and Zoning Commission, Tree Board, Parks and Recreation Board to order. Let it know we can order at 6:31. Clerk, please call the roll.
Alderwoman Haderlein, Schulz, Lavallee.
Here.
Carncross.
Here.
Lancaster. Here. Gorman.
Here.
Perkins.
Present.
Luna. Quorum is present.
Okay, thank you. You should probably also call the roll for the Tree Board and Planning and Zoning and Parks and Recreation, if you have those available.
Okay. Alderwoman Haderlein, Janet Hugg, Jay Wolf, Joel Crete, Shannon Kingzett, Sean Kingzett, Commissioner Jim Carbonetti, Albertson, Crevenston, Grisham, Hearley, McFafferty, Patnott. Alderwoman Haderlein, Lavallee.
Here.
Lancaster. Here. Salcedo. Logan. Here. Luna.
Okay, thank you. The majority of this is for City Council, so we have a quorum from City Council. We move forward. At this time, we'd like to admit Alderwoman Luna to attend the meeting electronically pursuant to Section 2.05.H electronic attendance at meeting rules. She met the criteria to be able to attend electronically by notifying the city clerk 48 hours in advance so that we could add it to the agenda, and her absence physically is an eligible reason for her to attend electronically. So we'll give her a call so we can get her on board.
Do we have to vote to?
There's no vote required to admit her. If you wish to not admit her, then you would need to make a motion to not allow that to happen. All right, Alderwoman Rosa Luna?
Yes.
All right. You can add her to the roll. Okay, thank you. We are now on item number 4, which is an application from IEPA, Public Water Supply Loan Assistance. And I will direct this to our city treasurer.
This is the, actually, Rob, do you want to explain the two options on the loan that we talked about this morning? And then basically we just need approval to have Christopher Burke move forward with the loan application for loan assistance. We've had this on the agendas a couple times.
Yeah.
We just missed it on the last council, so we are able to throw it on this one so we can move forward with it.
So this is for the water supply loan assistance for the lead service line replacement plan, and possibly recently was discussed replacing some water main that may qualify. So this would make a low interest or no interest loan available with possible forgiveness if we meet the right criteria. With our median income and our challenges, we would most likely qualify for forgiveness. There's no way to guarantee that, but from what Christopher Burke Engineering has said, that other communities that they've worked with have met these qualifications, and it's been successful for them.
I'll make a motion to
And
approve.
this, let me just add, this is, the cost for this loan application is $23,020, so we would need approval to spend that amount with Burke. Sorry.
I'm still gonna approve, but just, we have the funds in the general? for
We
it?
do, we're gonna be, using tap-on funds
Okay.
in the water fund, in
All
the,
right.
the money market.
I'll make the motion to approve.
I'll second it.
Okay, we have a motion by Perkins, second by Lancaster. Any comments or questions here? Hearing none, clerk call the roll.
Lavallee,
Yes.
Carncross,
Yes.
Lancaster,
Yes.
Gorman,
Yes.
Perkins,
Yes.
Luna.
Yes.
All ayes, motion carried.
All right, thank you. Item number 5 is the resolution to accept planning technical assistance services delivered by Chicago Metropolitan Agency for Planning, also known as CMAP. Administrator?
So this is something that was brought up. This is so that we can get a master plan for the walk path, bike path throughout the city. Part of it is at least guaranteeing that we're going to contribute $5,000 towards this project as it goes on.
5,000 a year?
Nope, just one time 5,000.
Okay.
I make a motion that we approve the $5,000 for CMAP
The resolution.
resolution.
I'll second the motion.
Okay, we have a motion by Gorman, second by Carncross to accept the resolution to accept planning and technical assistance services delivered by CMAP. Any other comments or questions here?
Just a quick question. How's for the bike paths, walkway, CMAP that we currently been doing? How far along are we with that?
Well, the original plan that we have was kind of sporadic and wasn't complete. This will take a fresh look at it and get us a complete plan for the entire city.
Does that affect what we had that was in the thing?
There's some that might be used. I can't guarantee
Okay.
that.
So what was planned in the last year or two might not happen now because we're doing this?
Which items are you talking about being
Well, I
planned?
thought-
The
well,
stuff
I
at
don't know. I
Ratzlaff
know we
going
had-
into the park? Is that what you're discussing?
Well, we had a few with CMAP. Go ahead, Charlie.
Yeah, there was a plan already put together by the Parks Board.
There was, yes.
And it connected through some of the city
Yes.
sidewalks as well. And I think what you're asking is, what was the status of that with this?
So that plan was never fully approved by city council or even the park board. But I believe that, that information would be considered in this technical assistance to create the new plan.
Okay.
All right, we have a motion and a second. Any other questions or comments? Hearing none, clerk call the roll.
Alderman Lavallee,
Yes.
Carncross,
Yes.
Lancaster,
Yes.
Gorman,
Yes.
Perkins,
Yes.
Luna.
Yes.
All ayes, motion carried.
Okay, at this time, then we'll move on to item number 6, which is conduct some training for elected and appointed city officials. We've been kind of wanting to try and get this accomplished for some time, so our city attorney will be conducting the training. And I think part of that is he's going to be handing out some of these books that the IML had created for elected and appointed officials.
Lisa?
I think it might have already been on.
Thank you.
Thank you much.
Is that better?
Third one of these.
I'm gonna have a whole library.
Can you hear me?
When you're not
Yes.
here anymore.
Firewood.
Go check it out. Well, I know we're trying to have some.
My name's TJ Clifton. I know most of you. City attorney, work at Zakowski, Rogers, Flood, and McCardle. Everyone
Counsel?
should-
Sorry.
Is that-
Can you speak in the microphone? I just know because when they're not speaking in it, no one on YouTube can hear it.
Yes, I'll try not to have you have to remind me of that 12 times during this, but, is that better?
Oh, much.
Wait,
Oh, yeah.
Now we're talking. All right, You should have all received a copy of a book that our office does with the IML. It's a handbook for newly elected officials. I added in there and long-term elected officials. It's a book I have in my office that I would say probably at least once a week or at least once every other week I go back to and just kind of for a refresher. So I'd recommend that take some time, look through it. If you have questions, feel free to reach out. I'd say about half of our law firm helps in drafting it. So everybody has a different role in that. And so if you have questions, don't hesitate to reach out. Purpose of tonight's presentation is to kind of just walk through just different ways to run a meeting, different roles that everyone has throughout the process, talk about specific procedures, and then the back half of the presentation will get into specifically some planning and zoning provisions and sections as development starts to pick up, and hopefully will continue to pick up here in the city. Just as a elected official or an appointed official on a committee, one of the first things that you ask yourself is what exactly is your role, right? Is it policy making? Is it operations or the administration? Obviously, the goal is that the council is speaking with one voice. There needs to be clear lines of authority about who should carry out a job, right? And so that's something we'll kind of get into is work with staff, work with the mayor, the administrator to make sure, and I think it's in one of the later slides, but you don't want every staff member to have 12 different bosses, the elected officials, right? There should be a direct line where if you have a question, you can communicate and get the answer to ultimately to your question. Continuing with what is your role, you have a professional staff, right? Obviously, there's been a lot of turnover over the last couple of years, but the city has a tremendous professional staff, and so the goal is to try and use them as best you can, and not necessarily just at the meeting, right? Like I think the best run cities are the cities where those inquiries of staff and questions of staff are asked ahead of time during the process, so when you get to the council meeting, ideally, all the questions are answered. Kind of what we touched on earlier, work through your president or administrator to deal with staff. Figure out the town structure, so if you have questions, if you're new, or if something comes up and you're not sure who to direct the question to, probably best to start with the mayor or with Lou and then let them kind of direct you where you need to go. I don't think we have this problem, but in some towns, it's very important to remind people to read your packet, right? Like, you shouldn't be reading things for the first time as you sit here and get ready to make a decision. Same thing with questions. You should read the packet when you get it over the weekend, a couple days ahead of time. And if you have questions, call ahead of time, right? Call the day of, call the day before. That way you can get those answers. If, there are certain situations where you may get an answer that may tell you, all right, we need more information on this. It's better to know that ahead of time than to decide that at the meeting. Obviously, you can't avoid that all the time, but to the extent you can preemptively ask those questions and talk to the staff, it does go a long way in streamlining the meetings and just making everything run a little bit better. Common example is if you're going to correct them, in minutes, if the word "the" should be "is," that's a simple thing. Like, don't waste time when you're at a board meeting. Just call the administrator ahead of time and say, hey, this typo needs to be fixed, get it fixed, and it's done. Same thing with talking to the staff ahead of time. Nobody likes to be surprised, and I think it helps move things along but give everybody a better answer if ahead of time you're reaching out to staff with your concerns. If you have a concern and you know that concern on Friday, Saturday, or Sunday, ask on Monday. That way, ideally, if they don't know the answer by Monday, come the meeting on Tuesday or just before the meeting, they'll have the answer, and ideally we can move things along. Next slide talks about civility. Again, not something that we're seeing here is a big problem, but just always remember that everyone's going to have different opinions. And unlike what we see in a lot of our political climate today, reasonable people can disagree. Disagreeing without being disagreeable, present your position, debate your position, but then, as the last part of this points out, once you guys vote, that's your vote. It's the council's vote, it's the city's vote. So, while you may not have agreed with it, if that's the majority, then that's ultimately the city's position. To the extent that there are complex issues that are more involved that may take, there might be a bunch more back and forth. Talk about considering strategic planning sessions or workshops on those specific topics. if we know down the road that there's going to be a big topic coming up that's controversial, doesn't hurt to do a workshopping session so it's not happening at a council meeting, but maybe do it during the day or start a little bit early so you have time to give yourself ample time to address those issues. With that, we'll move on to council, committee, and board procedures. At any point in time, if you have questions, don't hesitate to stop me. All right. A little theory with your practice. Just as you think about this and as we go through the different slides, what makes a good meeting? What's the purpose for the meeting? How do you accomplish your goals at the meeting? And is everyone going to be satisfied with the process? And I think that last one is important. You're not always going to be satisfied with the result, right? You may be the one no vote or the two no votes, but were you satisfied with the process? Did everybody have enough information when they made their decision? Did everybody have ample time to debate their decision or at least present their argument? And then was the decision made? And I think, like I said, I think that last one is very important and one that that way, even if you weren't successful in the position that you wanted, at least you felt as though the process was thorough and fair, which is, I think, what a lot of people want out of their government. This next one, don't stay up all night. Generally, I think we're very good at that. We don't stay out here too late. But the long meetings can become problematic, but it's not because short meetings automatically equal good meetings. It's generally because towns that have short meetings, generally, when they're running smoothly, it's because the legwork is done in advance. So when you guys are deciding or voting on things at the council level, they're things that you've already been involved with or already had knowledge on or already have seen at a committee level, or if you had a question, you've already asked it. So by the time it comes to the council, you're already well informed and you're prepared to make your decision. Again, if it's short, everyone stays focused and interested. Once we get to 10, 11 o'clock, everyone starts to get a little bit loopy, right? We all know that. We've had those experiences. But again, just because it's not like we want to be out here by 7:20 every week. If we can be out of here by 7:20 every week because we've done our homework ahead of time on both staff and council side, this makes things run a lot smoother. Have a plan.
TJ, can I
Yes.
ask a question about that?
Yep.
So, sometimes when, thinking back as a resident, before I was on the council, sometimes meetings going quickly and being very, efficient, can be frustrating for the people in the community because they don't know all of the background and they have questions and they're just seeing, motion, second, vote, done. And so I know I try, if there's something, and I think the mayor does a good job of explaining things, but I do try to ask questions about things at the council meeting, so that it's part of the discussion.
For sure, and that is, again, I think that there are, obviously, if there's a controversial or a sizable expense or a new, just something of significance, that we don't want to gloss over that in 30 seconds if it's an issue that residents are very concerned about. The ideal meeting is one that runs smoothly. It doesn't necessarily mean that it's a 5-minute meeting, right? Depending on what's on the agenda, there are certain issues that have to be addressed. And like you said, that it is important to either ask a question about it or even when you're, after a motion's been made, to take 30 seconds and say, just so everyone's clear, this is what we're voting on, this is the process that we went through, and this is how we ultimately got here. But I agree with you. There are, you'll see short meetings on these slides a bunch. It's with the caveat that making sure that everyone's informed and has the information.
So I just wanted to add to that. There's nothing wrong with asking the question at the council meeting, but one thing that helps a lot is, again, asking staff if staff can answer that question. So we have time to respond to it, or at least be prepared to respond to it at the council meeting so that, again, the information gets out to the general public. It's when the question's asked here that we have not had time to answer, then everyone has to wait till the next council meeting. So just add that.
Just one procedural issue. Let the record reflect that Alderwoman Haderlein has joined the meeting, and also tree board member Joel Creed. So.
Thank you. Back to having a plan, right? We all know the agenda. We've already walked through the agenda. Compliance with the Open Meetings Act, depending on the meeting, depending on what's on the agenda, that does control what we're able to discuss and specifically what we're able to take action on. As you can see there, if you call a special meeting, you're only able to discuss the items. There's a timer on this, it's annoying. You're only able to discuss what is on the agenda for that special meeting. At a regular meeting, what the agenda controls is what you can vote on. You're still able to discuss other things, you just can't take a formal action on them unless they are on the specific agenda. Finalize the agenda at the beginning of the meeting. That's something that we generally always do. Use a consent or omnibus agenda. We do that here. We kind of shifted, I think it was a couple years ago, to the consent agenda. The purpose to that is to, again, streamline the more routine things. And I think there's two schools of thought with the consent agenda. Some of our municipal clients literally put every single thing on their consent agenda, except for discussion items that they're not going to vote on. If it's just a discussion item, they'll pull that off. But if it's everything else goes on the consent agenda, and then it's on either a resident or the council or the mayor to pull those items off. Some people just put the routine stuff in the consent agenda and leave everything else off the consent agenda. The school of thought there is just kind of touching on what Alderwoman Haderlein said, is that you don't just want to swiftly go through everything and never talk about it, because then the public's like, well, when did that happen? What happened? So either way works. But generally, our rule of thumb is if it's a routine motion or a routine item, put it on the consent agenda. And again, some of our clients would rather just say, let's put everything on the consent agenda, and then we'll pull off the one or two things that are controversial or different or unique that we think ultimately need to be discussed. But with the consent agenda, it is important, I think, to describe exactly what is being happened, so that if a resident was to just read the agenda or come to the meeting, they could ultimately see what was passed, or at least read what ultimately was passed. We kind of touched on this before. Do your homework, read your packet, visit sites in advance. Like I said, I think generally this body is very good at that. At meetings, people will come up and say, I drove by this the other day and I saw this. I do think that helps a lot to give everyone context. Use effective staff reports. And this is more towards staff, provide memos on issues so that the council's aware of it, kind of walk through what you did to get to that point. I do think it helps streamline votes, the actual vote. If, a council member can look at your memo and say, okay, this is the whole process, this is why they're recommending this, that makes complete sense. Again, contact staff early, right? Like if you raise a question and staff's like, you know what, that's a good point, I haven't had time to think of it, it's a lot better to find that out ahead of time and let all the parties know, hey, you know what, we're going to table this, or we're going to consider this at next month's meeting because we got to do a little bit more homework. Then everybody's not here, excited, hyper, ready to go. But as we've talked about before, rely on your staff, rely on consultants that you guys hire and that you pay. The last one talks about using a committee system, which we do here in the committee of whole, which we're here for tonight. Again, stay on task, be careful of the minutia, refer issues to staff for follow-up, and then, again, for the 8th time, rely on staff. Public input required under the Open Meetings Act. And again, we have this here where we let the public talk at the outset on matters that aren't on the agenda, and then each time an item comes up, we do a good job of allowing the public to talk. Generally, pretty much all of our municipal clients do have time limits on public comment. If there's only 4 or 5 people making public comment, as long as the person's making reasonable, or at least advancing conversation forward, our position is generally try not to limit public comment, let people get out. Now, if you got 50 people here, and as we talked about, you don't want to be here till midnight and people are repeating the same thing, that's where it becomes prudent to put those time limits on and just ask respectfully that people not repeat what the 5 people before them already said. Again, something that we already do here in the city, post a sign-up sheet, saw it outside today when we came in, make specific time for them to be heard, and then, again, ask at the outset, especially with bigger meetings when you know there's going to be a bunch of public comment. It does help, at least in my experience, where the chair will say at the start, like, look, we know everybody has a lot to say. We'd ask that you just do not piggyback on, or not say the same thing, right? You can say, you know, what my neighbor John Smith said, I agree with, and in addition to that, but we don't need the same people repeating the same thing. Hearings versus meetings, right? Hearings, there's special required hearings, especially as we get into later the planning and zoning matters. A lot of those do require specific public hearings, and for a public hearing, there are specific statutory requirements that ultimately have to be followed so that the petitioners and objectors are, their due process requirements are met. And again, it's just a way that's designed to ensure the public is heard. There are specific notice requirements that have to be followed. And we do have a sample hearing outline that's in our book, but we'll also go through it on a slide here a little bit later. A lot of the times, like, you know, there's parliamentary rule, Robert's Rules of Order, and, you know, it can be frustrating sometimes. Why do we have to make this motion? You know, it's to avoid confusion. It's an orderly way to make sure that the will of the majority is being heard, and it also allows for predictability. Talking about what exactly do you do at a meeting. Obviously, the chair or the mayor runs the meeting. The members participate. They make motions, they second motions, they debate motions, and then ultimately vote on motions. Motion puts an item on table for discussion. Generally, just calling the item puts it on the table for discussion, but once a motion's actually made, now we're actually talking about an action item that the council can approve. An ordinance, we've passed 1 million of them, usually used to pass a new law or regulation, sometimes required by statute. If you want to amend an ordinance, you need another ordinance. Resolution's a little bit more specific, one-time action, and then a proclamation is more just like announcing the position or the intent or the feeling of the board or of the council. I think we talked about maybe a proclamation on the, was it the sidewalk thing a couple weeks ago? The issue that we're having with the state there. How to make a motion, observe common courtesy, let everybody finish their debate, wait for the chair to recognize you, and then the biggest thing is use plain English, and attorneys are probably partly at fault for this, but sometimes the way motions are worded, it is very unclear which way you're supposed to vote, right? Am I supposed to vote yes? Am I supposed to vote no? Depending on my position. So as you can see the examples here, I move to approve, I move to deny. The most common one we hear that gets people tripped up is I move not to approve. Or I'm, you know, so it's like, it's the double negative there. Now if I'm voting no, am I voting yes? It just becomes very confusing. We call it the Taylor Swift motions. Don't say I didn't say I didn't warn you. Avoid the I move not to approve, and Lou, go with I move to deny. And again, that's just, and one thing that we talk about is in staff reports, it doesn't hurt, or even on the agenda, which I think we do a good job of, is it's okay to outline, like, if you're in favor of this action, this is the motion to make. And it does make it a lot easier for everybody sitting up there when they have 1 million thoughts going in their head to just have it right in front of them. Hey, this is the motion that we need to make if we want to move this forward. No archaic practices. If you make a motion in the positive and then vote against it, okay to seek input as you craft a motion. And again, I think that's something we do pretty well here is somebody will make a motion and then we, we'll kind of remind them of certain things that maybe they want to add to their motion. Get a second or the motion dies. After the motion's seconded, consideration, have a discussion about it, and then ultimately make a vote. Here's some examples of I think it's 4 different motions that were ultimately made, and it never got anywhere. So the first motion, commission brought a motion to deny the zoning request. It was no second, so because there wasn't a second, it didn't get to a vote. Then they bring a motion to approve the zoning request. Again, there's no second, so the motion failed. Then there was a motion to continue the hearing to obtain more information. They got a second, but then the vote was a tie, so that means that it failed, so that didn't work either. Then there was this another motion, this time to deny. This time there was a second, and the vote again was a 3-3 tie. So you have 4 different motions, and you're effectively right where you were when you started. But that's just kind of some different examples of what happens to the motion. Amending a motion, this is the very specific conservative way to amend a motion. Generally, this isn't how it goes. Usually somebody makes a motion, there's a second. If they amend it, then the person that seconds it just says, I second the amended motion. Technically, the conservative route is that you actually vote on the amendment. If you approve that, then you're voting on the amended motion. If the vote to allow the amendment fails, you then are voting on the original motion. Very, very confusing, and that's where we talk about the Robert's Rules of Order. Sometimes that almost gets in the way of what everyone understands, but technically, that is the way that amendments to motions which have already been made are supposed to be made. Tabling versus postponing, these are words that everyone uses interchangeably. Technically, there is a difference there. If you table it, you're effectively killing it because you'll need a motion to remove the item from the table. And so what we generally encourage is if you want to postpone something, you say, I want to postpone it until a specific date. The same thing effectively happens if you say, I want to table it to this date. You're really just postponing it. What I think the way it used to happen is you table it and it would just go away until somebody brought it up at another meeting to have it back. So if you use table or postpone, the important thing is that you're setting it to a specific date so it doesn't have to, so it's not killed and doesn't have to be revived, if that makes sense. Calling the question or limiting debate doesn't come up very often, thankfully. Usually everybody's able to get through their debates, and then ultimately we get to a point where we're ready to have a vote. However, you can make a motion to call the question, which essentially ends the debate. It has to be seconded, and then there has to be 2/3 approval in order to actually call the question, which means the debate effectively ends, and there needs to be a vote on the motion that is pending. Motion to reconsider. I don't believe that we've had this issue since I've been working with the city, but essentially what happens is if, let's say, tonight on one of the items that we voted on, somebody has second thoughts. It could happen again tonight, so still while we're here, somebody could file a motion, make a motion to reconsider, or alternatively, at the next meeting, city council meeting or something like that, there could be a motion to reconsider, but it has to be made by a person that was on the prevailing side or the successful side. So you'd have a vote on the motion to reconsider. If that vote is granted, then you would vote again on the same motion. You don't get to amend it. It's the same exact motion that was previously voted on. Situations where we've had this happen is where controversial issues, certain information is presented one way, motion passes, and then between then and the next meeting, more information comes out and it's determined that the premise that the council voted in favor has shifted and that's not actually what it was. So now you want to fix it and change that. The end of the motion, again, after it's made and you second it, call for a discussion, and then ultimately anybody that wants to comment can comment, and then you ultimately take a vote. A voice vote where the chair asks for ayes and nays. Any member may move for an exact count or a roll call. A roll call vote is where each member is called by name. If you don't vote, right, so if you refuse to vote, your vote will be counted if you are in the room, even if you refuse. If the specific vote requires a concurrence of the majority, then your non-vote will be counted with the majority. If it requires an affirmative vote, your non-vote will count as a negative or against the motion. Minutes. Obviously, we do these at every meeting where we're approving the minutes from before. Again, these are the most common. Read them ahead of time if you have questions. Then go ahead and ask them at that point in time. That's kind of the focus on motion practice, meeting practice. We're going to move now into planning and zoning stuff. Does anyone have any questions on that first part before we move on to the next part?
I would just say, let the record reflect that Alderman Schulz has joined the meeting.
No question? All right. Moving on to planning and zoning, and specifically the Planning and Zoning Commission. And these, it says Planning and Zoning Commission, but obviously these issues also come to the City Council as well once they go to Planning and Zoning. The different state laws that control the Plan Commission, zoning and setback lines, and then specifically within the City of Harvard, we have the UDO, which was passed a few years ago and which we're now in the process of considering amendments to. The UDO is obviously the governing document for zoning and development within the city. The relevant sections of the UDO, Article 3 talks about the zoning districts, Article 8 talks about our uses, 13 talks about the administrative bodies, 14 talks about the administrative procedures, 15 talks about applications, and then Article 17 talks about enforcement. Zoning maps and districts, there's the zoning map for the City of Harvard. Obviously, all the different colors represent different zoning districts. So if there's a zoning map amendment, those colors will change as that area, in the event that that area is amended. Planning and Zoning Commission is appointed by the City Council. It's an advisory or recommending body. They recommend different things to the City Council based on requests that are presented to them. As noted, and as we'll touch on in a little bit, there are hearing requirements for many of these responsibilities as we consider different zoning amendments and variations. Hearings for these, especially the controversial ones, which primarily for the municipal matters, the contested hearings generally have to do with zonings, whether it's a subdivision, whether it's a variance that, neighbors may agree or disagree with. So having a predictable but a consistent hearing procedure is something that is very important. Kind of back one of our first slides, we talked about ensuring the process is one that everyone is okay with and feeling that they had the opportunity to be heard and they were able to present their argument. I think running a hearing a certain way and giving people in an orderly fashion the option to present their argument is important. I think sometimes hearings, and this happens all over, can devolve into a back and forth between two people or between two factions or different sides. I think it's important that's acceptable, and that's obviously what happens at hearings, but I think it's important to have parameters for when that conversation occurs, how that conversation occurs, and then move things on so that we're not rehashing the same things and getting into arguments as opposed to actually presenting issues that are important for the consideration. At the start of a hearings, who's ever the chair should confirm with staff or the petitioner that proper notice for the hearing has been given. Generally for zoning hearings, there's different requirements, be it that the notice be published, be it that it be posted on the property site, be it that adjoining property owners be notified. Explain the purpose of the hearing, and then I do think it's also important to outline for, a lot of times when people come to a zoning hearing, it's probably one of their first times doing so. So they have no idea, do I get to talk now? Do I get to talk at the end? Once they talk, am I done? So it's not a bad idea, and I just did the Taylor Swift thing. It's a good idea to outline the process or the procedure that you're going to do for your hearing ahead of time so people know, okay, so they're going to get to talk, then I'll get to talk. Okay, that's good to know. So they can kind of gather their thoughts and then ultimately proceed or partake in the hearing. Ask all parties to take an oath. Generally, because it is a hearing, we'll ask that witnesses be sworn in, sort of tell the truth and nothing but the truth. That can be done by the commissioner or who's ever chairing the meeting. Sometimes our office will do that as well. The general process, and at the end and also in the book, there's a whole outline of the hearing procedure that we recommend. But usually you start by having the petitioner, be it the city, be it a resident or a developer, have them come in and give a presentation. Allow the commission or the council members to ask questions during the presentation. Once the petitioner is finished, generally staff will be asked to give their report and outline what the staff's position is based on, again, their professional experience and their evaluation of the project. That's also another time where commission members can ask questions of staff if they have concerns. They can certainly ask those questions during the hearing. Once all commission members' questions have been answered of the petitioner and the staff at this juncture, generally then you shift to public comment and give those people the opportunity to make a statement, present questions. One thing that I think is more advantageous or runs a smoother hearing is if I'm going to speak in public comment and I want to ask 3 questions, that is not the time for the petitioner to answer those questions or for staff to answer those questions, because then what happens is it devolves into a back and forth, and inevitably, especially if it's a contentious issue, that back and forth isn't going to stop anytime soon, and it's going to quickly devolve into something that is not productive at all. So generally, the best way that I've seen meetings run is they get up and they make their comment. They can ask questions. In a sense, they're rhetorical at that point because we're not asking for anyone to answer them right away. Obviously, the petitioner and or staff should be taking notes of those and be prepared to address those once we swing back to them. But it's just generally more prudent to take those answers at the end as opposed to engaging in a back and forth. Yes?
You mentioned about the importance of asking questions of staff and so on when it comes to council members. Is the same true of commissioners? I mean, should they be meeting with staff and so on prior to hearings?
Yeah, to the extent that they can, yes. I mean, it may be, I don't know the timing of when everyone gets everything, but yeah, to the extent that you have questions for staff ahead of time, I'm sure staff appreciates getting the question ahead of time as opposed to, when they're kind of on the spot here. But also just that gives them time to know, okay, these are issues that I need to make sure that I address. Because most likely if you have a question, there's residents that have that same question. So sometimes if you ask that question 2 days in advance, then maybe in Donovan's staff report, he's addressing that issue right away. And so now the 3 residents in the back that have those questions are like, oh, that makes sense. Okay, I was concerned about trees. He just addressed the tree issue. Perfect. So if you're hearing those, yeah, it certainly helps to ahead of time reach out and say, hey, this is one concern I have about this project. Then we'd close the public comment portion of the hearing, and that is something that we do recommend is once you've allowed everyone to speak is to actually close the public comment. Then you allow petitioner and staff to respond to any comments that they feel necessary or that they feel that they need to respond. And then commission members again can ask questions of staff and the petitioner, and then you ultimately close the hearing and have the vote and have the discussion, which I think we'll get to here. Yeah, when discussion is complete, solicit a motion in a second, and then have the vote in the hearing. But again, it seems like a simple process. It obviously gets much harder when there's a bunch of people here who are agitated or passionate about their position. And so I do think that getting into that specific routine and running it the same way, as you can see, it allows everybody the opportunity to speak, but it does so in an orderly fashion, and it doesn't devolve into a back and forth in which emotions start to run high. Here's an example of a sample agenda. It kind of is the same process that we just went through, but a lot of our municipal clients will have this, the chair will have this right up at their meeting, and we'll just kind of check off the box as they go through it. And it does really help to streamline it, but also to make sure that you're giving everyone the opportunity to touch on an issue if they want to. We'll get into specific zoning requests, text amendment, map amendment, variance, conditional use, and special use. The slides will have all the factors. I'm not going to bore you and read every single one of them. But text amendment is a request to change the words of the zoning ordinance. So the example we give here is if beekeeping is prohibited in a specific district or a specific portion of the ordinance, a zoning text amendment would be a request to change that to allow beekeeping. It can be specific to a zoning district, or it can be to the text as a whole. A zoning map amendment is a request to have a property classified as a different zoning classification, right? So from residential to commercial or vice versa, and anything in between. Again, I'm not going to read these, but the UDO at Article 14.2E1 does have specific approval standards. None of these, an application doesn't have to meet every single, you consider the factors as a whole and look at if it satisfies the approval standards for a zoning map amendment. Next, it's zoning text amendments. This is Article 14.2E2 of the UDO. Again, factors that are to be considered when making a determination as to whether or not the zoning text or zoning map amendment. So when people give presentations, especially petitioners, the ones that are well versed and have done it and have done their homework will come in and they'll tell you, like, okay, this zoning text amendment is appropriate because of, and they'll run through these factors and tell you why, or these standards, and tell you why their proposed amendment meets these or why it's not applicable. And these are all based off of, they're called the LaSalle factors. It's based upon a court case in which the court determined what factors are relevant or should be considered by a public body within zoning issues. So the standards that were just on the two slides before this, essentially the genesis of them is these LaSalle factors. So the gain to the public / loss to the owner. What does the public gain by the request relative to the hardship imposed on a property owner? What's the suitability of the zoned use? What's the time of vacancy, right? So if a property's been zoned as X for 5 years and it's never been developed and it's stayed vacant, that's something to consider when you're considering a zoning text or map amendment. The public need for the proposed use, and then how does it comport with the comprehensive plan? And like I said before, no one factor is controlling. It's generally, you should consider them all and then make a determination. It is important on these zoning issues that you do make findings of fact that the request is compatible with the use or zoning, that it's supported by the trend of development. And these are, again, just general with the LaSalle factors, but it is important that you make facts that, based upon your opinion and your research or information provided, that it does satisfy the approval standards for the specific request. And especially, so there will be times where, the zoning board may make a recommendation based on certain findings of facts, and where this body may ultimately differ from that. If that's the case, and you're ultimately going to overturn their recommendation or not approve what they recommended for approval, it is important to indicate why, right? Like, they found these facts to be true. We actually think that these findings of facts are more appropriate, and that it doesn't meet these standards, or it does meet these standards, and here's why. So it is important to differentiate that, just in the event that there's litigation down the road. The case law holds that having those findings of fact, or at least acknowledging why the difference or why you approved it, can be helpful to that. Variance is a grant of relief to an owner from the literal requirements of a zoning ordinance. We've dealt with a bunch of variances, whether it be setbacks, size of buildings, heights of buildings, any of that fun stuff. Again, the UDO has specific standards for a variance that when one is presented to you, these are what you should consider in determining whether or not to approve or not to approve the variance. Conditional use or a special use is essentially a use that is allowed in a zoning district, but that we have placed certain conditions on in order for it to be approved. So it's permission by the municipality to use the property in a way that is not ordinarily permitted, typically because the use is unique in nature. It has to do with how the land is used. And it's important that with a conditional use or a special use, to the extent that they meet those extra those extra criteria that are set, if they satisfy those, then a special use generally should be approved, because by considering or having something be a conditional use, it has been determined that if those conditions are met, it's an approved use or an appropriate use. So that is something, like we always give the example of, it's like a bakery in a zoning district as opposed to a pawn shop, right? You may like the bakery that the 70-year-old grandma is running a lot more than the pawn shop that's being run by, a shady looking character. But if the pawn shop meets the criteria for a special use and the bakery doesn't, technically the pawn shop has to be approved because it meets the criteria. You're regulating or you're voting on a use, not an actual person. Or whatever it ultimately is. Again, standards, all of these have standards. No one has them memorized, but it's important before a meeting when you're considering one of these that you consider the different standards that the UDO has established that we're to consider in making these determinations. Again, make findings, whether you approve it or deny it. Limit your decision to the standards that the UDO outlines. A lot of zoning case law will be where bodies have considered irrelevant or extraneous things. It kind of goes back to my pawn shop example. Your decision needs to be based on the standards, not necessarily your personal belief about whether or not a car wash is appropriate at that location. If a car wash meets the standards, then it meets the standards, right? Whether you like it or not. Now, if there's reasons why you don't like it that also go to those standards, then that you're well within your right to say this doesn't meet the standards and here's all the reasons why. And that just, again, talks about have a reason for your decision, otherwise you subject yourself to litigation. Plan unit development, these are obviously subdivisions or developments that have multiple different parcels. It's essentially a conditional use or a special use. The one thing with a PUD is that you don't need specific variations. The PUD in and of itself is essentially a variation, so all those kind of get rolled into one. You're not doing a separate variation hearing for every single thing. As we talk about, it gives you flexibility and control to control all the different things, again, within a subdivision, within a commercial strip mall, something along those lines. It gives you that ability to have more control over that and deal with all of the property as a whole as opposed to each individual parcel. Non-conforming uses, essentially what a lot of non-conforming uses is when, let's say, right now your property is in compliance, but then the zoning code is changed and your property no longer is in compliance. It's technically a legal non-conforming use, so essentially you're allowed to continue that until certain exceptions, like say you have a house that now is in a commercial district, you get to keep it as a residence, but if ultimately there's a fire and it has to be rebuilt, now you do have to come into compliance. There's different exceptions and stuff that go along with that. And that is the presentation for tonight. Does anybody have any other questions? Nothing? All right.
All right,
Thank you.
thank you. That brings us to agenda item number 7, new business. Is there any new business for the council to consider? Council, anything? All right, hearing none, I'll accept the motion to adjourn.
I'll make that motion.
Second.
Motion by Perkins, second by Carncross. Clerk, call the roll.
Aye.
All right, thank you. Good night.
Thank you.
I hate when that happens. No, we